Thank you very much. Good morning, everyone. After a great introduction by Mark of some of the complexities of data protection, I'm going to be dealing with a bit more of the nitty-gritty of some of the sort of contractual issues around data protection, security issues on cloud computing. And I would think probably if I go non-stop through my slides, it's probably going to take me 15 minutes or so, 20 minutes. So hopefully there's been opportunity for some questions afterwards and get a discussion, good debate going like we did before would be great. And again, I think copies of my slides, either from myself or the organisers, are available afterwards as well. So kicking off, data security privacy. As we know from the talks before the coffee session, the issue of location, the overriding obligations, certainly for UK European users, companies, to make sure they're taking adequate data protection measures, and also making sure that for data transfers, there again, adequate protection in place, are the drivers behind this part of the cloud computing and have led to some of the obviously concerns in the past, which has been a drag on greater take-up of the service. One of the key topics which was, I think, touched upon, and I think Mimecast offer this, for example, is our regionalised processing. Is that on offer? Some providers don't offer that, others do, so that if a UK European organisation, you can be relatively assured that your data will be held, hosted and processed within the EE, and others actually say nothing about it at all. One of the interesting things from a recent survey of providers and their terms is that one or two providers do refer to the fact that they can have regionalised hosting and processing of data, but actually when it comes to the hard terms and conditions, they're silent. So one of the things for any of the lawyers or commercial managers is do make sure that this the opportunity and the options to go for this are backed up by relevant warranties and express obligations in the contract. In relation to protecting data and the data confidentiality issue, of course, there are two main concerns we've got. One is accidental loss or destruction of data, and the second would be a provider disclosing data deliberately to third parties who ask for it. Now, one of the problems we've got in relation to both is that in most of the standard cloud contracts, there are very little express warranties or guarantees in relation to data confidentiality at all. A lot of disclaimers are in place, and in addition, there are a whole range of clauses, some of which say we will only release data to the third parties if there's a court order, and we're forced to effectively by our national system. Others that say we have a discretionary right to do that, and others which really more or less give the provider complete discretion to disclose data, almost if their business in their business discretion, they're allowed to do that. The A drive clause is an interesting one. I bring this one to attention. This is typical of, I'd say, a lot of the middle range of providers, those that don't offer the most protection, because as you see from the clause here and the quote, the key things here, they will provide information to law enforcement agencies and their discretion, but also the second thing right at the end is they will provide information in relation where there is any potential illegality or where A drive themselves may be exposed to legal liability. You probably won't be surprised that A drive is a US-based organisation, and I think the point was made earlier on that generally speaking, US providers of cloud computing services tend to keep themselves a much wider margin of discretion in both disclosing data to third parties, whereas a law enforcement angle, but also where they think in their own business discretion, they may be liable to legal exposure if they don't. And of course, we know US providers, subject to US rules, have a whole range of legislation that we don't have, such as the US Patriot Act, etc. So certainly when you're coming to decide between which provider is for yourselves, if you're in that situation, do check the terms and conditions of one or two competing suppliers, and certainly as a generalisation, most European providers are going to be more liberal and more sensitive to the issue about keeping data confidential and only disclosing it in limited circumstances, such as a court order or where there is a legitimate concern, rather than just avoiding their own legal exposure. Glad to hear that Mimecast, obviously with a UK base, I think we already covered that because they accept UK jurisdiction, and I'm sure it's sensitive to that issue. But it is one out there where a lot of providers are still actually quite resistant to giving the protection that most users would expect. Data integrity, the same comments on the slide in relation to confidentiality apply here, that in relation to key express obligations on keeping data whole and complete, most providers are very wishy-washy on that. Again, depending on your bargaining position, do try and push back and get express warranties, express obligations to the extent you can. Another interesting area which often people don't concentrate on is what happens at the end of the relationship. what obligations, what safeguards are in place in relation to you, say as a user, going in and either getting all your data back or being reassured and absolutely 100% confident that at the end of the relationship, the provider will actually delete it all and destroy it so that it's not floating around on the cloud long after your relationship has ended. Again, on data preservation bullet points, there are a range of express obligations or express terms you would expect to see. Some providers, the better ones, will say they will keep it for, say, a month or a short period after termination, and then they will delete it, allowing you to go in and either having it transferred back or putting in place mechanisms whereby you'll be reassured that it has all been deleted at the end. Others state that it will be deleted immediately on termination, which is a slightly worrying one because if ever you get into a dispute situation, there's also a potential possibility that you have a dispute with a provider. They say, oh, we're terminating this contract. The terms allow us to actually delete all your data immediately. I would hope in practice they wouldn't do that, but of course, if it was a wrongful termination, the provider themselves might be in difficulty because they've taken an act that can't be sort of undone. They've wrongly terminated and your data's gone. Doesn't help you as a user. Other providers have a sort of a hybrid approach whereby they say they keep a discretion to keep your data for either a specified period or a reasonable period after termination, after the end of the relationship. So again, important to bear in mind that, obviously we hope everything goes right during the transaction, but at the end of the term, what does happen? What does happen? Do you have the right to go in effectively and either check that it's all come back to you? What protections are in place? And that's actually why I was particularly interested on the audit question, because even if you have the sort of standard provisions in place whereby, you get written confirmation undertakings that everything's been returned and or destroyed, how do you really know? And as you're saying, I think it's Nathaniel said, security, and I suppose security in this sense as well, ultimately depends on the provider. So if you do have a right of an audit, where the third party or what have you, that can cover those sorts of angles, that would be helpful. Because it's still one of the areas that certainly negotiations on behalf of users, you can go so far, but you never really know whether it's going to be complied with or not. Service outages. Now, depending on the exact service itself or the actual data, the data availability, the data hosting, data processing, it's quite common that you'll often have some quite high-level, impressive uptimes promised, often 100% or nearly 100%, which looks very good. But of course, you need to look beyond the fine print, because the actual uptime will not be 100% of actual time, real time, not 24/7, but it will be subject to a number of exceptions and a number of limitations you need to bear in mind. For example, downtime, in other words, breach, will exclude many items, which you might think it would include. Also, the outages, service outages, so breaches by the provider, will often be tied quite closely with the service level agreements. And again, unless you're in a fortunate position of having a very strong bargaining position, those service level agreements are pretty much one-sided in favour of the provider against most users. The SLA normally will be tied to a service credit type regime, where typically you might, for any sort of service outage, there may well be a cap of, say, 1 month's service fees, sometimes a little bit more, sometimes a little bit less, which is often going to be a very small remedy if there's actually a serious breach. Often, of course, that service credit will be expressed to be a sole legal remedy as well. And again, in terms of real life loss to a company, to a user, that sort of service credit, whether actually it was 1 month, 3 or 6, can pale into insignificance to the real loss and cost of the company if there is a serious data loss or downtime. Also, even if the SLA and those mean service credits aren't enough, there often, as we've come on to deal with, be a sweeping limitation clause, either limiting liability to a relatively small amount or excluding certain types of loss altogether. So again, the impressive uptimes in the contract or the early documentation are not as impressive as they actually may sound, and in particular, downtime, in other words, things that you might try to claim under the SLA and service credits will not include a lot of the issues there, a lot of the items there, any acts or omissions of the user which have led to downtime, any scheduled maintenance, for example, and actually the scheduled maintenance can be scheduled, say, quite typically in some contracts, a week, 24 hours, 48 hours before the actual downtime itself. So actually, it's almost the provider saying, well, actually, tomorrow we're going to shut down the system for a certain amount of time, and that's not downtime you can count against us in relation to service credits. Also, force majeure events, any act outside the control of the provider, and any third-party actions and omissions. So the bottom line is, although the uptimes may be quite impressive on the face, in reality, digging below that and seeing the exclusions as to what doesn't count as a downtime, the actual uptime you're getting in practice is not as impressive as it might otherwise look. Moving on to remedies and limited liability. I mentioned that, again, service outages often be tied to an SLA, service credits which are payable. They'll be quite mean and quite small and often won't cover your real loss in real life circumstances. In addition, as I say, there's then the secondary level of limitation of liability, which is always, cloud computing and IT service contracts generally is obviously a very hot, sensitive issue because, again, we've got this classic issue that even big IT contracts worth a few £1 million, if they go horribly wrong, the actual losses to users are multi-millions. And so often arguing in the UK as to whether limitation of liability is effective or not basically decides whether or not it's worth actually arguing or going to court at all, because the recompense you'll get if the limitation cap applies means that it's really not worth fighting any further. Typically at the moment, and again, it can vary for one-off big bespoke contracts with big players, but generally, direct loss flowing from breaches of the cloud computing contract and service will be limited to, say, 12-month service fees, sometimes a bit more, sometimes less. Indirect and consequential loss is excluded altogether. And as well as indirect and consequential loss, there's usually a whole raft of things which, on their face, are also excluded altogether. And they'll include typically loss of profits, any loss of revenue you suffer, data loss, data destruction. And of course, that's an interesting one because quite often a lot of the services you're going to the cloud for will be specifically database services. So, I'm coming to you for a service, essentially the service is data service of one sort, and quite often on these contracts you'll have a clause saying data loss, destruction excluded. Now, US providers, again, tend to be stricter than UK European ones because their law allows just, parties to sort of contract on whatever terms they like generally. There aren't the legislative controls, checks and balances that we have. So again, if you're in a position to check either rival providers, do check for limitation of liability clauses as well. It's an interesting question. For example, I've referred to UCTA, UCTA. That's the Unfair Contract Terms Act. And that, for some of you who don't know, would mean that in a standard term, in a contract for standard terms on cloud computing, if there is a clause that says, liability is limited to X or it's excluded altogether, it's for the provider to show that that is a reasonable limitation of liability. Now, generally, in IT contracts and other contracts, to be honest, indirect consequential loss being excluded would generally be okay. I just raise here, if you have the right sort of situation where the cloud computing contract is dealing specifically with a data service, and you have that standard data loss and destruction is completely excluded, speculating, but I could foresee situations where a court was saying, well, you're effectively saying on this contract there's no remedy at all. And if that's the standard term, there may be some scope for actually, arguing that that is an unreasonable limitation or exclusion. And the legal effect, if you're successful on that, is that the limitation clause, exclusion clause is invalid. And then a user could actually say, well, I've suffered £1 million of loss. That clause doesn't apply. If I can demonstrate my loss, I get it all back. Now, that's speculation. And I must say recently the courts have been fairly consistent in saying, business parties are big enough to look after themselves, and it might be tough, but we're not really here to change the contracts unless there are really compelling reasons to do so. I just wonder whether in cloud computing circumstances, a total exclusion of loss for data destruction, data loss, might be an exception or provides a ground for sort of an exceptional case. I want to point out some of the pitfalls. I don't want to worry you too much, of course, because a lot of what I've just said in relation to limitation of liability, and I've touched upon it, is not actually a million miles. It's very typical of IT contracts generally. So I must redress the balance and say it's not, I think, here that suppliers are suddenly putting in terms and exclusions, limitations, which are not known to the IT sector or other sectors generally. They are. And so to that extent, it's really, you could say, it's par for the course. It's just another type of IT contract. Nothing particularly different about that from a legal perspective. I think the thing that does make it potentially different, as I say, is that we're homing in now on lots of potential services which are really wholly dealing with data. And so that old line in the contract saying that any data loss or destruction is completely excluded, I wonder whether that will still wash. Of course, the provider, suppliers, can legitimately say it's reasonable because actually we're pointing out that really what should be happening here and what the contracts